case. This is oral argument on Burkett versus Dryja et al. It's our number CV-25-0143. Each counsel has 20 minutes, as you know. You may use whatever time you'd like for rebuttal, but you need to keep your time yourself. So please proceed.
Thank you, Your Honor. I'm Brian Laird. I'm up here from Tucson. I represent the Dryjas. They were defendants at the trial below, appellants at the Court of Appeals, petitioners here. The background of this case, it arises from a neighbor conflict. So the Dryjas got a new air conditioner, and their neighbor, Ms. Burkett, thought that it was too loud, and had a complaint to the Homeowners Association that this was causing a nuisance. So, as these things sometimes do, the case did not get resolved. It didn't get resolved through an agreement prior to a lawsuit. There were attempts throughout. I'm just going to say parenthetically that this is obviously a very small factual case. But the unfortunate thing is that once in a while, you have a very small factual case that has important legal issues. That's what happened here.
Is there a difference between, made me wonder, CC&Rs, you move into your house, you don't really have an opportunity to negotiate terms. It's take it or leave it. If you want the house, you get the CC&Rs.
Correct.
Does that make a difference that these aren't negotiated terms? And really, beyond that, it's not even if you say it's analogous to a contract of adhesion, there's still no real is there really an opportunity for the party bound to reject it?
I think that's a really important point, and it's key with CC&Rs. So first of all, when you move into your home, you get a copy of your CC&Rs. So you actually get a copy, and you get the chance to review them before you move in. So you do have that opportunity. Now, realistically, not everybody is going to go pouring through the CC&Rs. I move into a new HOA, I'm going to, probably everybody up here will, but real human beings, maybe not. The important distinction, though, is that with CC&Rs, you have a political process with the CC&Rs. And by this court's prior decisions, you have rights to change those CC&Rs, and by the CC&R's own terms, you have rights to change them. So if there's a provision in the CC&Rs that you don't like, or that you think should be changed, you can engage in that political process in the Homeowners Association, and you can take the steps that are necessary. Now, if you're unsuccessful, you're unsuccessful, okay? In every one of these situations, just like in every legal conflict, in every HOA dispute about what the bylaws should be or what the CC&Rs should be, you may have people on the other side that see it differently. So I guess the difference between this and a contract of adhesion, or for instance, the case in Zambrano, where you have a construction contract, and you kind of have this expectation, well, nobody's going to actually read that entire provision and understand it. Here you have the opportunity to change through a political process. So I think that's important, and it protects the people involved. And again, for every term in CC&Rs that one homeowner doesn't like, one other or maybe multiple other homeowners will want that provision in there.
Counsel, can we get to a particular term then within those CC&Rs, 10.3 enforcement and remedies? And the question that I have for you here, aside from whether or not this could be changed through a political process, through amending the CC&Rs, the last sentence of that particular provision references that prevailing party or parties shall be entitled to recover. In the event that a homeowner is successful in defending against an enforcement action, if it's only the HOA that could be subject to having to pay attorney's fees what's the reference to multiple parties?
Okay, so I just want to say that I think that's, again, this is a very good and important issue. The problem that happened here was that the Court of Appeals, after the trial court, interpreted the CC&R's plain language contractual provision pursuant to case law under 341.01, right? So they didn't look at it and say, we're going to look at this, it's a contractual provision. The contract is otherwise enforceable. Therefore, what do? We look at the plain meaning of the written contract that we have in front of us. And if there's ambiguity, if there are other contract issues, then we'll interpret it according to Arizona law as to contract interpretation.
Well,
So-
before we get to whether or not, I'm sorry, I don't want to interrupt you on that, because I think that's another issue for us to address. What's the nature of this agreement in order to get to the point you're raising? But just in the first instance, I'm looking at this language, and whether we want to call it a contract, whether we want to call it some regulation for the HOA, whatever it is, my question is, this references prevailing party or parties from the losing party or parties. Is that if this really is just an enforcement action between the HOA and a homeowner, where do we get multiple parties from?
Okay, so I think this contract term is very carefully and well written. It was well lawyered in the drafting. And the point is this, when you have these kinds of disputes in an HOA, you are often going to have, almost uniformly, you're going to have a complaint against the HOA, and you're also going to include the individual homeowner or homeowners, right, whose conduct is at issue. So you're going to include everybody as defendants who you want the court to order to do something. If you don't include the homeowner, then the trial court is going to say, well, I can order the HOA to enforce this, but I can't issue an order against this homeowner directly. All I can do is say, hey, HOA, here's what you have to do, okay? So as a matter of practice in litigation, you are always going to see in these cases that it's not just going to be the HOA that's sued.
So if I'm listening to your argument carefully, it seems to me you're suggesting that a homeowner who is essentially an indispensable party to an action would be considered among prevailing parties or among losing parties. Correct.
You may also have multiple parties as plaintiffs, and only the HOA. That's happened in other cases. So that is exactly the point. This provision is drafted such that it says if legal proceedings are instituted, that happened here, we know that happened, and they are in connection with the enforcement of rights and remedies under the CC&Rs, then the prevailing party or parties shall be awarded their costs, including attorney's fees. So this is not, and here's where the Court of Appeals, I think where the error starts. The Court of Appeals at paragraph 8 in their opinion, they say, they acknowledge first of all Zambrano, but they don't quote the rule in Zambrano. They say, we don't take this lightly, that we're gonna strike a term from a contract, but they don't cite the actual language from Zambrano and the rule from Zambrano, which is very clear, well articulated.
And they never cite Zambrano again, is that correct?
They never bring it up again.
Okay.
So having passed by Zambrano and saying we don't take it lightly to edit this contract, they then go on and say, but the CC&Rs authorize fees only in connection with the rights of enforcement and remedies provided in the CC&Rs, not in connection with other claims. But that is not what 10.3, the provision says. It just says if there are legal proceedings, if there's a lawsuit, and it's in connection with enforcement, then everybody who's on the winning side is going to get an award of attorney's fees, and everybody who's on the losing side we'll have an award against them. And again, when you're in this neighborhood and neighbors situation and you know you're going to get sued, I'll just tell you, my clients, the Dryjas, they are what you would call innocent parties. They were sued. There was not a nuisance. The court found that there was not a nuisance, and that was never appealed. But at the very beginning of this, the Dryjas had a choice, right? We've been named as a party. Now, we can either capitulate and give in to the other side and do exactly what they're saying, even though we haven't done anything wrong and we're not causing a nuisance, but we can just surrender, or we can appear and defend, right? They chose to appear and defend, and it is sensible that all of the prevailing parties in these situations, and I really believe that's why the provision is written that way.
Moving to a different provision in the contract, do you concede that the provision of the CC&Rs that pertain to nuisance rules is merely a restatement of existing common law nuisance requirements?
I think as it applies to this case, yes. It has additional language, so it isn't limited to the language from the tort cases. But again, it clearly was specifically written to encompass and to include that common law tort duty. It says there shall be no public or private nuisance. It's clear the lawyer was thinking about the case law of nuisance, because otherwise you wouldn't think to distinguish between public and private. There's a lot of case law distinguishing those two kinds of nuisance. So yeah, I think it is.
So it's followed, that language that you're talking about is followed by the word nor, and then there is verbiage after that. And I think you mentioned that offhand. Do you think that additional language reflects common law nuisance principles?
What I think is it reflects specific kinds of instances that people don't want to have happening in their neighborhood. And where that came from, I really can't divine. I don't know a specific nuisance case, and I never looked to see if there's some specific nuisance case that contains that additional verbiage and that it got brought in for. I've read nuisance cases before, and it never struck me in reading this provision that additional language was from some past case law. But I can't tell you that with certainty.
Mr. Lund, let me ask you this. Just hypothetically, say that the CC&Rs did not have a fee shifting provision in it at all.
Yep.
And the Burkett, or I guess of the trust, sued for nuisance for the same thing, and just under common law nuisance, a tort action. And they got together, the neighbors, and we think we have a good defense. We want to fight this in the lawsuit, and for whatever reason, both parties agreed that whoever wins will have to pay reasonable attorney's fees, and they document that in a written contract so that each agrees that they will give fees if they lose. Would that be an enforceable contract?
I cannot see any reason why that would not be enforceable if it was an express written provision. I think the award of attorney's fees is a separate issue from the duty of nuisance itself.
Well, what I'm asking is that a freestanding contract that's enforceable on its own? Because you can see where I'm going with this. I'm just wondering if it is there any public policy reasons that couldn't be enforceable? Does it not need an exchange of consideration? Definiteness of terms, all the things that we learn in law school for a contract.
I think in that situation, that hypothetical, you would have a separate consideration. We do this all the time. We do walk-away settlement agreements.
Well, exchange of mutual promises is that
right.
as long as it's adequate.
Those promises themselves would be, and that would be separate from the tort duty. You'd just be saying, And you do that also in high-low agreements in injury cases, right? So I think that would be very similar, and therefore I do think that would be clearly enforceable.
So that's kind of how I was thinking about the case that I would certainly be asking you as well, when your opposing counsel argues, is if it's okay as a freestanding agreement, what's problematic about putting it in the CC&Rs?
Yeah. Well, and if we're talking about the fee shifting agreement, just that provision, I don't think there's any dispute that fee shifting provisions in CC&Rs are enforced all the time. So what happened here was that because the 7.18, provision 7.18 anti-nuisance provision was included and was the basis basically of the whole dispute, then the Court of Appeals said, well, in those cases only, we're going to say that the two neighbors, just the two neighbors, cannot collect attorney's fees against each other. The big public policy issue here to me is this. This is not really a public policy, but the legal issue is this. The importance of people's expectations in written agreements. There's the larger issue of, like, we believe in ordered liberty, emphasis on liberty, but we do have to have control, right? But the other thing is that people rely on written agreements for decision making. So, I mean, if you don't know whether written agreements or and provisions, specific terms within an otherwise enforceable contract are going to be enforced, the impact on reasonable and good decision making is really strong. It's really harsh, right? In this case, you have Ms. Burkett, who filed this suit and refused to settle before filing, during, at the end of the case, all the time saying, my attorney's fees have to be paid, and I'm going to win my attorney's fees in this case, right? And so clearly, her decision-making was directly impacted by her understanding that this nuisance term was enforceable, and that's why the complaint is written, and there's a breach of contract claim in the complaint against the Dryjas as well as the HOA. And it says, you violated this term, 7.18, you have a nuisance.
So is it
sorry.
Oh, no, so is it your position that 12-341-01, that we need not even address, I mean, to resolve the case, is it your position we need not even address 12-341-01 or any of the case law? There have been a series of cases under that statutory provision. Is that your position? It's completely irrelevant to resolving this case? Yes,
I think that this is there's a very important legal issue that can come from this case, and this is an opportunity to explain to the court, to the appellate court, look, if you have a otherwise enforceable contract and it has a fee-shifting provision in it, then the way that you analyze that is through contract law. It's not through 12-341.01.
Counsel, may I ask you a question? You were starting to talk about this earlier, and then I drew your attention to 10.3. But what do we do about our case law, though, that characterizes CC&Rs as an agreement between individual lot owners and the HOA, not as between the individual lot owners?
Yeah. What I understand the law to be, and if I'm wrong, I'm wrong, but my understanding of the law is that the agreement is between the homeowners as a whole and each individual homeowner and the homeowners association. And again, in this case, what you have is a complaint that is filed. It includes a claim, a specific count for breach of contract against the Dryjas by their neighbor, the plaintiff. And I think that that's not only appropriate, I think that that's, well, my experience, that's exactly how this is done pretty much every time you have an enforcement action in HOA and you're using CCRs.
In your answer to the complaint, and so I'm asking for you to direct me to it if I missed it, but it seemed that your request for attorney's fees didn't reference 10.3. It referenced the statutes that we've been discussing and other applicable contractual provisions, statutes, rules, and laws. Maybe I'm feeding you the answer here. If it's a leading question, so be it. Is a reference to other applicable contractual provisions to 10.3?
I'm not sure I understand the question, but we made a claim for attorney's fees both under 10.3 and also under 341.01.
Because I don't see the specific reference to 10.3 in the answer to the complaint.
I know that this was an issue both at the trial court at the fee application hearing and the Court of Appeals. That's what I've got for you at the moment. And I see I'm out of time.
You are. It goes
Thank you all
quickly.
very
Thank
much.
you.
Appreciate it.
Okay, Mr. Hill.
May it please the court, I am Alan Hill, representing Stephanie Burkett. At its core, this case is a nuisance case. Ms. Burkett sued her neighbors because their air conditioning was making too much noise and she found it to be a nuisance. Ultimately, the trial court did determine as a matter of fact that the noise was not sufficient to constitute a nuisance, so she did lose on the facts. However, this is not a case that actually requires the declaration for her to bring that claim. Section 7.18 of the declaration says no owner or resident shall create or suffer to exist any use or operation on a lot which is a public or private nuisance, and it goes on. This provision was included in the declaration specifically to give the HOA the right to enforce and enjoin nuisance by its owners and members.
Then why were you suing the Dryjas, if that's so?
Well, she was suing the Dryjas under any theory that she could reasonably put forward.
Does that include breach of contract?
It does, and ultimately, it was not a breach of contract. But the form of the pleadings is not determinative of the law that actually applies. If an attorney comes up with an ingenious way to claim fees that ultimately doesn't hold water, then it doesn't hold water.
Well, if an attorney came up with that theory, it was you, not the Dryjas, because in your complaint, you specifically file a claim against them under the CCNRs and ask for attorney's fees against them under the CCNRs.
Yes.
So at one point, when you thought you might prevail, you seemed to think that the CCNRs would produce attorney's fees. But now that you haven't prevailed, you would deprive the Dryjas of that exact same argument.
Your Honor, I don't have an encyclopedic knowledge of the trial proceedings or the reasoning that went into the initial pleadings.
No, I'm talking about the complaint.
But we did, my understanding is that that claim was made in the hopes that ultimately they would be able to acquire attorney's fees on that grounds. And that at the trial court, the judge determined that, in fact, even without the CCNRs, Ms. Burkett would have the right to sue her neighbor for nuisance, and that right is not dependent in any way on a contract.
So what prevents, though, I get it, she could have sued, you could have sued just for nuisance. You don't need the contract, the CCNRs for a nuisance claim, but what prevents the parties from deciding we want a fee shifting provision for any enforcement of the CCNRs? I can see why homeowners might want that, because they think, okay, I've got a good case, I'm going to get my money back then on fees, so I'll go forward. Why can't parties agree to that?
I'm not actually able to find any law that clearly answers that question, and I've checked other jurisdictions to see if I could find anything persuasive. It's
Well, what
an
about
unusual
what
gap.
about Zambrano that did say that parties are free to contract as long as it doesn't violate public policy? So I've been kind of searching for why would that violate public policy if people want to agree to reimburse each other for reasonable attorney's fees in any lawsuit?
Well, I think in theory, it's probably allowable for parties to contract that if you commit this tort to me and I commit this tort against you and we sue each other, we can get attorney fees. But there needs to be independent consideration there. In this situation, Section 7.18, it simply mirrors a pre-existing duty. There's no separate consideration offered for this. And an interpretation of this provision and its purpose that I think is most reasonable is that this exists so that the HOA can do its job. And it does not exist for the purpose of restating tort claims in order to allow all the neighbors to sue each other and then recover attorney's fees.
Do you have any authority? Oh, sorry. Do you have any authority though for the proposition that you need separate consideration for particular parts of a contract?
Your Honor, I think it's the Wank versus Horizon Storage case, if I'm not mistaken. Nope, that's not right.
Don't we look at contracts as a whole? Aren't the CC&Rs an entire contract?
Generally speaking, yes.
And why is this different? Was the nuisance provision an addendum to the contract? Was it added after the fact? And if it wasn't, why would we need consideration specifically for that provision?
I think in this situation, the fact that the nuisance provision, if interpreted as a restatement of the rights of enforcement among the members, fails because it's illusory. It's not actually committing anything more to the contract than what already exists at law. And a provision that commits no more to the contract than what already exists at law is not enforceable. So this provision can be struck with regard to the individual owners, obviously without being struck with regard to the HOA, and rendered unenforceable because it's illusory. It adds nothing. And I think that might be a better way of framing it than the failure of consideration, because then we do get into the question of what consideration generally was offered, and obviously it's a binding contract. We're not disputing that.
But the second provision, Justice Bullock brought this up earlier in the 7.18, there's that second provision that begins, nor shall any music, noise, or sound that is objectionable be allowed to emanate from the lot. And that objectionable language, because I was weighing this too, and it seems different and almost a lower threshold for a violation than a common law nuisance claim that requires, as I recall, unreasonable interference with a person's use and enjoyment of the property and that causes substantial harm, as opposed to the CC&Rs that just reflect something objectionable. So it almost seems, so that's what I wanted to give you an opportunity to explain. Does that second, the remainder of the sentence that begins nor shall and it addresses objectionable noises, doesn't that add something above and beyond for homeowners than merely a common law nuisance claim?
The trial court and the appeals court both found that it did not. And I don't believe that the petitioner has requested that be reconsidered. I think essentially in this situation, the established law of the case is that it does not. It provides no more than a restatement of what the party's obligations are under the law.
Well, do we have to follow that if we disagree?
I'm not going to tell the court how to weigh these issues. I don't think that would be my place, but we would argue that as it's not been specifically raised as an issue, we don't think it should be part of any decision.
Counsel, Justice King asked a question of your opponent about 12-341-01, whether it's relevant or not. Obviously, the Court of Appeals spent a lot of time on that statute. Your opponent said that it's really not relevant. Again, the Court of Appeals spent a lot of time in cases such as kind of fleshing that out, such as Sparks, Barmatt, and Ramsey. That really was what they considered and ultimately was instrumental in their disposition in this case. I'm going to give you a chance to respond to tell us why 341-01 is relevant and why those cases are instructive.
Your Honor, the entire Sparks and Barmatt line of cases is relevant in this situation because it's persuasive, because it shows how the law draws a line and a distinction between tort claims and contract claims, between claims that arise from a contract and those that don't.
In any of those cases, was there a separate fee shifting agreement in those cases, in Barmatt, Ramsey? Because I ask that because I think that is the dispositive distinction in this case and those.
I think all three of the cases, Sparks, Barmatt, and Ramsey, all lacked a specific fee shifting agreement, which is why 341-01 was being evaluated. In this case, the specific fee shifting agreement, I think it's important to look at the specific language here. It starts out, it doesn't start out, but the relevant portion. If any court proceedings are instituted in connection with the rights of enforcement and remedies provided in this declaration. And the petitioner has argued that in connection with is broader than arising from. And for that reason, the 341 materials aren't necessarily relevant, that we don't need to do that analysis. We see this a little differently. That is that a claim cannot be both in connection with the contract and independent from it. Because Ms. Burkett's claim against the Dryjas is not arising from this contract, is not based on this contract, despite what she initially pled. It is, in fact, independent and not in connection with the rights of enforcement. The rights of enforcement belong to the HOA or to an owner standing in the shoes of the HOA to carry out the restrictions and covenants and enforce its terms. The way this case played out, we have an indisputable enforcement action by an owner of a home in the HOA against the Moondance Estates Association. That is not disputed. But that was an enforcement action trying to get them to do what Ms. Burkett believed they were required to do under the terms of the declaration. The fact that she was arguing that the nuisance by Burkett had to be addressed by the HOA does not mean that the two claims are actually in connection for this purpose. It means that, well, it doesn't mean that they're in connection because one is independent and we have multiple defendants here. There's no requirement in law that all the defendants be treated the same with regards to fee shifting provisions. And ultimately, there is public policy in the state of Arizona that says that tort claims are not entitled to an attorney's fee award. So unless the Dryjas can clearly show that, in fact, these two things are clearly connected and that the members do have the right to claim attorney's fees in any dispute that touches on the subject matter of the declaration, then attorney's fees are not appropriate. And I think ultimately, from a public policy perspective, that question about just how much granting attorney's fees in this case would extend the availability of attorney's fees among the owners of HOAs beyond what has been practiced or intended, I think that's a relevant policy concern. That effectively we are transforming the fee shifting provisions of an HOA from a contract between the owners of a community as a whole and each individual owner into a contract between and among all of the owners. And that creates a maze of reciprocal fee shifting obligations.
Well, again, I return to the point that you elected to sue them, and you sued them under the CCNRs. Isn't there an equitable consideration there? Again, you were asking for attorney's fees against them. Why shouldn't they be allowed, especially when there is a fee shifting provision, if they win, to ask them against your client?
I think that our position on that goes back to the Wink versus Horizon Storage case. That is that the form of the pleadings does not determine the law. Even a party's stipulation as to the law generally doesn't determine the law. So if Ms. Burkett's complaint misstated the source of the duty that she was alleging had been breached, then the fees still cannot be awarded.
I guess what some of us are really trying to pin down is whether your position has changed. Did you originally believe that she was entitled to enforce the fee shifting provision under the CCNRs, and now you're walking away from that position?
Well,
now you no longer believe that?
I know that at the complaint stage, it was believed to have merit. I don't know if it was considered to be a long shot, but I think it was considered to have merit, or I'm sure that the complaint would not have been filed. So to that degree, yes, I think she has changed positions on this issue upon the trial court's decision, which is admittedly favorable to Ms. Burkett. She decided that that was the correct decision. And, speaking as her counsel here, I think that there is a serious risk that granting fees in this situation requires an expansion of fee availability in declarations.
Let me ask you something that I've been mulling over for about the last 10 minutes, something you said, I think, in response maybe to Justice Lopez's question, that the nuisance provision is illusory, effectively, against the individual homeowners, and it really only applies to the HOA. To me, that seems to say that you can't include in your contract terms something that also, that there's a separate independent duty, public or private duty, that would give rise to a tort. Is that essentially what you were saying?
Essentially, yes.
Okay.
Generally speaking, simply restating pre-existing tort duties fails because you're not actually offering anything.
Yeah. Then, we see a lot of cases where people allege both the tort and the breach of contract. And so I'm thinking particularly in construction, for example, you get a lot of breach of implied warranties, things like that. It's also a breach of contract. I believe the law says that you can bring those simultaneous claims for breach of, as long as it's specific in the contract, it's okay that it's also a tort duty. You can sue on both. Now, when it comes to getting fees, that's a different deal. Or even damages. That's when we get into my least favorite subject, the economic loss rule, when you have those dual claims. So it takes me a little bit off when you say you can't put that in there in a contract because, as I say, for example, in the construction law, you have that a lot, that comes up. So can you give me some kind of authority that says you cannot put, to back up what you said, that you can't have an enforceable provision in a contract that is simply a restatement of a tort duty?
Well, I think with regard specifically to the construction law cases, those are implied duties. So those are duties implied by law into the contract. And without the contractual relationship, those duties would not exist. So even though it's a tort, it arises from contract because in the absence of that contract, that duty would not exist. That's not the case here. In the absence of this contract, this duty would still exist. I think that's the primary differentiation.
Okay, well, that's fair enough. Can you give me a case or some kind of authority that stands for that? Outside the context where you have a tort arising from an implied duty. I can think, I mean, I guess you're right with malpractice, you might have a contract with the lawyer that's also going to give rise to breach of contract, sometimes also legal malpractice, going to have it with doctors, going to have accountants. All of that comes from a contract. I suppose you could say here that the contract placed the neighbors into the same, proximity that you could have a nuisance. But I'm trying to find that line of do you have any authority saying you can't have a public duty restated in a contract?
I was not able to find any, actually. I think that's actually why we're here, is because there is no case that clearly states that parties cannot simply contract for a pre-existing duty as a provision in another contract. Right? There's no case that clearly says that out. I would argue that there should be, because simply restating duties at law in order to try to create fee shifting, I think is contrary to public policy.
Thank you very much. Thank you both, counsel, for your argument today and your briefing on interesting issues to ponder, and we will take the matter under advisement and issue a written due course. Stand adjourned for the day.